Filing an order of protection. Petitioner. The order of protection is divided into three parts: the petition for an order of protection, the emergency order of protection, and the plenary order of protection. According to Illinois Legal Aid, an emergency order of protection, or EOP, is a court order that protects its holder, called the petitioner, from harm by a person named in the order, called the respondent. An EOP takes effect as soon as the judge approves it. Because of the risk of harm, the law does not require the respondent to know about the hearing. This is known as an ex parte hearing. Because of this, an emergency order only lasts for 14 to 21 days. When the court issues an EOP, it sets a hearing date for a plenary order. A plenary order is issued by a judge after a hearing with both the petitioner, the person seeking safety, and the respondent, the person accused of abuse. The petitioner must be present in court to get the order. To begin the process of obtaining an order of protection, you will first need to complete a verified petition for an order of protection. This document tells the court if you qualify for an order of protection under the law, why you want an order of protection, and what items, called remedies, you are requesting through your order of protection. In the state of Illinois, you are eligible for a domestic violence order of protection against offenders who are family or household members who are related by blood or by current or former marriage, share or shared a common home with the offender, have or allegedly have a child in common, or are in or have been in a dating relationship, or are high-risk adults with disabilities abused by a family member or caregiver. You or the person you are filing the order against must live in the county you are filing the order in, or you have relocated to this county to avoid further abuse. The petition for the order of protection is the document that allows you to tell the court your story about what has happened and why you want the order. Be as specific as you can about the events and how it has impacted you and those you want protected on your order. Because notice of this court proceeding must be provided to the other side, the person you are filing the order against will get a copy of this document and will be able to review what you have written. The petition for the order also allows you to inform the court of the protections you are asking for, also known as remedies. The judge can grant up to 18 remedies, from prohibiting further abuse to ordering the offender to stay away and have no contact directly or indirectly with you. You can also ask for possession of a household, vehicles, and property. If you have children with the person you are filing the order against, you can request child support and outline your preferences for allocation of parenting time and significant decision-making responsibility. According to Illinois Legal Aid Online, parenting time is defined as the time that both parents spend with their minor children. This used to be known as visitation. Significant decision-making responsibility is defined as the responsibility to make important decisions for a child in the areas of education, extracurricular activities, medical care, and religion. The court can allocate decision-making responsibility to either or both parents in each of these areas. You may also request the respondent attend counseling and turn over any firearms they may have. When you complete the verified petition for the order of protection, the documents for the emergency order of protection and plenary order of protection are created at the same time using the information you entered into your order of protection petition. When you are first requesting an order of protection, the type of order you will be asking for is called an emergency order of protection. An emergency order of protection can be in place for between 14 and 21 days and is allowed to be granted without notifying the person you are filing the order against. After you complete your order of protection petition, you will file the petition along with the other documents that are created at the circuit clerk's office in the courthouse. The clerk will create the official court file and file the documents with the court. The clerk will determine what judge your case will be assigned to. Once your case is assigned to a judge, court staff will escort you to the courtroom. You can also have an advocate from the Domestic Violence Assistance Center present with you at this time. The Domestic Violence Assistance Center is an office located in Winnebago County Courthouse that can assist survivors of domestic violence with obtaining a domestic violence order of protection against a current or former intimate partner. When you arrive in the courtroom, you may have to wait for a period of time until the judge is ready to hear your case. Once the judge is ready, he or she will call your case and the courtroom bailiff will show you where to stand in the courtroom. The judge will review the order of protection petition you prepared and may ask you some questions to better understand why you are seeking an order of protection and what remedies you are seeking. At this time, the judge will decide whether or not to grant an emergency order of protection and will let you know their decision. Whether or not your order is granted, the clerk will escort you back to the clerk's office so you can receive the necessary paperwork. If your request for an emergency order of protection is granted, the judge will inform you of your next court date, which is usually about 2 to 3 weeks away. The clerk will provide you with copies of your emergency order of protection and your order of protection petition. Copies of these documents will be sent to the sheriff's department so that the person the order is against or respondent can be served with the paperwork. Although your order of protection is active at this time, the person cannot be considered in violation of the order or arrested for violating it until they are served with the paperwork by the sheriff. In Winnebago County, you can register to be notified when the respondent is served with the order of protection and will also be provided with a number to contact for more information regarding the service of the order. If the person you filed against lives in a different county, you will need to send the order of protection paperwork to the sheriff's department in the county he or she is located in. The clerk may assist in creating an out-of-county packet for you to send to that county. You must bring back verification of service or non-service to the next court date, or file the affidavit of service in the clerk's office before your next court date. If your request for an order of protection is denied, there are 2 different things that can happen. One scenario is that the judge does not find sufficient reasoning to issue an order of protection, and your request is denied and the proceedings are over. In this case, the order would not be sent out for service to the person you filed against. The second scenario is that your request for an emergency order is denied, but a hearing is set for the plenary order of protection stage. A plenary order is issued by a judge after a hearing with both the petitioner, the person seeking safety, and the respondent, the person accused of abuse. The petitioner must be present in court to get the order. If this is the case, you will be given a court date in about 2 to 3 weeks, and the person you are seeking the order against will be given notice that you are attempting to obtain an order of protection against them and they will be provided with the paperwork. If your emergency order of protection is denied and the court sets the case for a hearing, but you do not want the case to proceed, you can ask that the petition for order of protection be dismissed and the case would be dismissed altogether. If a second court date is scheduled, it is at this time you may request that a plenary order of protection be granted for up to 2 years. This is the second stage of the order of protection process and is called the plenary stage. The person you have filed the order against, or respondent, also has the opportunity to come to this court date. If the person you filed the order against, or respondent, does not want the order in place, they may request a hearing for the judge to decide whether or not the plenary order should be granted. You can request that the plenary order be granted for up to 2 years, but can also request a lesser amount of time.